But thank you so much, everybody, for being here. I know we have a couple of people joining us in person, of course, and then we have folks online. Thank you for taking the time to hear about the Corporate Transparency Act. My name is Shruti Gurudanti, and I am the partner and director of our Corporate Transactions and Aerospace Division here at the Rose Law Group. My name sounds funny, but literally just say all of the letters. You're not saying it wrong. I promise you. If you have any questions, comments, concerns as I'm going through this presentation, please go ahead and drop your questions in the chat. Feel free to raise your hand. I would hate for this to be a death by PowerPoint. This is a very interactive session, and my hope is that you can walk away with some really, next steps or actions that you can take in your life and your business going forward. So with that, again, thank you for being here. This session is being recorded and it will be available for you all to take a look at if you have any questions that were not answered during the session. Okay, so with that, as any good lawyer would start with, I have to start with a disclaimer. Anything I say in this presentation is very much for informational purposes only. It is not legal advice. I hate to say, but the Corporate Transparency Act, unfortunately, is something that got implemented or became effective January 1 of 2024, and it is ever evolving. They had new FAQs and new clarifications issued as of October 3rd. So anything I say right now might change in the future. So please always reach out to your legal counsel or somebody on my team that can help answer any specific question that you have on this issue. So a quick update. I often get this question, do we even need to care about the Corporate Transparency Act right now, given that there is a lawsuit that declared this particular as unconstitutional? And the answer is yes, there was a case. There was a case in the District Court of Alabama, in the Federal Court of Alabama, and it was declared unconstitutional. However, the ruling is limited to the very specific plaintiffs in that case. So if you are Mr. Isaac Winkles or the National Small Business Association, or your entity is a member of the National Small Business Association, then yes, you do not have to file the Corporate Transparency Act reporting until the case is resolved. However, if you are not one of the plaintiffs, please note that the FinCEN, the Department of Treasury, has said that everyone else is required to comply with this specific filing requirement. Also, as an FYI, there are lots of states that are looking at passing their own state-based corporate transparency acts. So if you are based in New York, if you have an entity based in New York has passed what's their local New York Transparency Act, which I believe gets implemented in 2026 or 2027. So just keep an eye out for that. And then of course, California, Maryland, Massachusetts are actively considering something like this. So even if we're questioning what's happening at the federal level, note that states are taking, taking a view on this particular requirement. So what is the Corporate Transparency Act? How did it come about? And why did it even arise in the first place? So this is something that passed with bipartisan support. And it was actually something that came about during the Trump administration before Biden came on board. And it is essentially, the goal here is to help understand who are the ultimate individual owners of entities, so that the intent of the government is so that they can try to stop bad actors. They want to know if there's money laundering, drug trafficking, human trafficking that is taking place through shell entities. And they want to basically know who the ultimate owners are. Unfortunately, the US is one of the, I think, top 3 destinations for shell entities and to do all sorts of money laundering work. So they're trying to come around and find out who the beneficial owners are. So Congress has directed the Treasury Department's unit called the Financial Crimes Enforcement Network, or FinCEN, to establish this national registry of beneficial owners. And this national registry is non-public. It's only available to law enforcement and certain other entities that I will talk about going forward. But it is secure, it's maintained through, the highest standards of security measures and things like that. So that's the intent. Now you can consider it good or bad, but I think it comes from a very good intention to try to find out who the ultimate owners are. And I've heard everyone complain about it, that it is very cumbersome for small business owners and it's taking a lot of time, this, that, and the other. If you have a very simple ownership structure, I promise you it should not take you more than 20 minutes. It's simple, it's free, it's secure, it should be done straight away. Now, the complexities arise when you have very complex corporate structures with multiple entities. That's when you have to really start digging into how do these rules apply. But if you are a single entity with, a simple ownership structure, you can do it on your own. It shouldn't take more than 20 minutes. So we're going to talk about who must file, when must you file this beneficial information ownership report, what information is required, and what are the penalties for it. And again, if you have any questions, just please stop me. So who does this apply to? Essentially, the law says that if you are any corporation, LLC, or any entity, whether foreign or domestic, that had to file some sort of paperwork in the United States in order to do business here. So you filed articles of organization or articles of incorporation with the State Department. Then you are considered a reporting company subject to the filing requirement, unless an exemption applies. And there are 23 exemptions. So the easy way to think about this is if you are a general partnership, if you're a sole proprietorship, you have a trust, and these entities were formed without filing any sort of paperwork with the government, you are not presumably a reporting company and you don't have to make this filing. So let's talk about the exemptions. This is the fun part. So there are 23 total exemptions. And those generally are companies that already are doing some sort of filing requirement with some other form of federal or state government, like the federal government. So think large publicly listed companies, banks, insurance companies. These guys already have a lot of disclosure requirements that they have to do. So the government has said that these entities are exempt. Now, I will talk about a couple of important ones because they are likely applicable to more than average number of companies. So your tax exempt entities like 501c3s, those don't have to file the beneficial information ownership report. We'll talk about large operating companies, inactive entity, and then the wholly owned or controlled subsidiaries, as those are three that could likely be applicable to you all. So if you're a large operating company, that is, you're an entity that employs more than 20 full-time employees in the US, you filed your income tax for the last year showing more than 5 million in gross receipts or sales, and it's an and, okay? And you operate a physical office in the US through a lease or you bought a space, you are considered a large operating company and you are exempt, okay? What is an inactive entity? I get this question all the time, especially from my real estate guys. We've created 5 entities that we're just waiting to see if we might buy a property and then, we'll see what we want to do with it. So if you have an entity that was in existence prior to January 1, 2020, okay, it wasn't engaged or it's not engaged in any active business. And what does that mean? It doesn't hold any assets. It's not seen any ownership change. It has not received or sent funds more than $1,000. Then it's considered an inactive entity. So for example, if you have a shell corporation that is a holding company, meaning it holds ownership interests in 5 other entities or even one entity, that is not an inactive entity, okay? It holds assets in it. So it doesn't qualify for this exemption. But if you have an entity that's just you created in 1998 because you wanted to, just keep it there thinking I might come up with a business and it qualifies because it hasn't had any, money changed in the last 12 months and, all of the other items are satisfied, then yes, it is an inactive entity, it's exempt. I will recommend though, if you have any entity like this, please go ahead and terminate it. And when you need to file and form a business, create a new entity, just so there's no question about whether or not you qualify or don't qualify, just go ahead and shut it down. Okay. So next we're talking about, and I'm just gonna move this so I can see. Okay, the subsidiary exemption. Okay, so this is an extremely controversial exemption because there's a lot of back and forth with FinCEN about what does this exemption mean. The way that they've defined the subsidiary exemption is that if you are a wholly owned or controlled subsidiary, meaning if there's an exempt entity, so say it's a 501c3, which is an exempt entity, right? And if an exempt entity either 100% owns the ownership in a subsidiary or controls the ownership in a subsidiary, there's a difference. It owns or controls the subsidiary ownership, then the subsidiary is also an exempt entity, okay? But be very mindful that they've not given any explanation as to what they mean by control of ownership. So there's been a lot of back and forth with the FinCEN on this, but as of today, this is sort of how they've defined it. So if you have a large operating company with 20 plus employees, you have 5 million in revenue that you've reported, you have an office here, and you have a wholly owned subsidiary, that subsidiary is exempt. Now, interestingly enough, if that changes in the future, that means you sell 50% of ownership to somebody else, you lose that exemption for that subsidiary entity. I know this is a little complex, so if you have any questions, please put it in the chat. Any questions here? No? Okay. All right. Okay, so recent clarifications. So like I said, the Corporate Transparency Act is evolving every couple of months. Every day there's something new that's coming up. And as we are practically filing these reports, there are things that we're learning on how practically this sort of shakes out. So as recently as of October 3rd, the FinCEN came up with more FAQs trying to clarify how these rules are being applied. And I just picked up some of the important ones for all of you all. Dissolved entities. So all of my folks in M&A, that's my primary practice, mergers, acquisitions. We constantly have deals where we have to create an entity and then immediately it merges into the next sort of entity and create the rest of the transaction. Even those entities that are created for a short period of time, if it was created after January 1, 2024, it is subject to the beneficial ownership information report filing. Does that make sense? So if you form an entity after January 1, 2024, even if it existed for one day and you dissolved it or it turned into another entity structure, you will have to file the BOI reporting within 90 days of its formation. I've had many clients say, we formed an entity, then we changed our mind, we dissolved it. Do I still need to file this report? The answer is yes. Do I need to get an EIN for this? Likely the answer is yes, unless you can show it's a disregarded entity and you can use the Social Security or the EIN or ITIN for the parent entity. Okay, so if you dissolved it, but it existed in 2024, please go ahead and file it. Disregarded entities, they're not required to obtain a separate EIN. Also very interesting that the FinCEN has released. They can use the owner's Social Security or ITIN and comply with the reporting requirement. Last but not the least, the government understands that everyone's trying their level best to try to understand these rules and file as soon as possible. So as long as you can show good faith effort and you are reasonably filing these things within, a reasonable amount of time, you're using your best efforts, that is something that is going to be looked into by FinCEN or by the government to make sure that you're compliant. So try to be reasonable and don't actively try to avoid filing. Okay, so when must an entity file? So this is a one-time report. You don't have to do this annually, but you do have to file it depending on when the entity was formed. So if your entity existed prior to January 1, 2024, then your deadline is December 31st, 2024. Millions of entities have already filed this, but I know there are a million more that have not probably filed this. So please, now is the time to start looking into it, because you never realize how complicated this is until you start getting involved in figuring out who the owners are. If you're an entity that was formed after January 1, 2024, then you have 90 days from the date of forming the entity to complete the filing requirement. And if it is going to be formed after January 1, 2025, then you have 30 days to complete. So just keep these timelines in mind. If you make any changes to your report, meaning your entity has changed its physical address, you do have to update the report within 30 days of the date of change, okay? So it is sort of ongoing as a reporting requirement. So what information, this is the easy part, you have to talk about your entity, who the beneficial owners are, and the company applicant. So the full name, doing business as, current address, all sorts of mumbo jumbo. Really what they're looking for is they want to have a unique ID, so your US passport or foreign passport, driver's license, something of the individual beneficial owners. Okay, so we'll talk about the FinCEN identifier. The FinCEN identifier is essentially like a social security number. If, for example, I have various entities, if I do, instead of me giving my passport every time I'm filing this for an entity that qualifies, I can go ahead and get what's called a FinCEN ID. And then I can use that FinCEN ID for all these various multiple entities. Okay, so here comes the crux of what everyone wants to know. So who qualifies as a beneficial owner? And I'll stop for a second. If you have any questions, Madeline, in the chat, Okay, we'll get to it at the end then. But please keep posting your questions. So who is a beneficial owner? A beneficial owner is essentially someone who directly or indirectly, again, please, directly or indirectly has substantial control or owns or controls 25% of the ownership in the reporting company. So sort of going backwards, if your entity qualifies as a reporting company and is subject to the Corporate Transparency Act, then the government wants to know all the way to the top who is the individual owner who directly or indirectly either controls the entity substantially or has 25% or more of ownership. I get this question a lot. What does substantial control mean? Think of it as people who have the authority to majorly influence the decisions of the company. So your senior officers like CEO, CFO, president, someone who can appoint a majority of the board, so on and so forth. The interesting thing is they have a catch-all provision right at the end saying that an individual who exercises any form of substantial control over the reporting company. So if you have a person who, even if they're not on the board, they're not a COO, but they still somehow substantially influence the reporting company's decision, then they are likely an individual who needs to be reported. And then they've defined substantial control as, again, direct or indirect. Ownership interest. So this is the tricky part. Again, I get this question a lot from a lot of our sophisticated clients who have multiple entities and profits interest and convertible notes. All of those are included when you are trying to calculate 25% or more of ownership interest. Okay, it doesn't have to straight be equity. It can be any other form of instrument, contract, arrangement. So if anyone is in the cannabis industry, you have a management contract, that management contract is going to be considered as substantial control over the company or 25% more of ownership interest. Okay, so who is a company applicant? So the government wants to know information about the reporting company, the beneficial owners, and they want to know information about the company applicant. So a company applicant is someone who is responsible for essentially filing paperwork for the company. So think of your lawyers, your general counsels, CFOs. Those folks need to have their information disclosed as part of the beneficial ownership information report if this entity was formed in January 1, 2024 and after. Okay, I'm kind of going through this as quickly as I can, but please, I hope you're leaving any questions that you have in the chat. Updating reports. So if you have changes in the report after you file the very first one, you changed ownership, there was a change of address, you changed, I have clients who have companies held through UTMA accounts, so for their kids. So any changes when it comes to, you know, change of ownership interest, all of that has to be reported within 30 days. And again, they're very serious about non-compliance with this specific law. So perfect segue into what are the penalties. They are not joking, you guys. If you willfully fail to comply with this requirement, or you willfully provide false information, the fines go all the way up to the $591 a day, as long as the reports are inaccurate or not filed, and it's adjusted annually for inflation. You could also be subject to criminal penalties of $10,000 in fine and 2 years of jail time. So again, the notable piece of this is you have to willfully fail to comply with this requirement. However, you really don't want to be running into trying to prove why you need to stay out of prison. It's just not worth it. Who are they going to get behind, or who are they going to try to find at fault here? Both the individual person, so ultimate beneficial owners, as well as the entities are going to be charged with non-compliance. So please take this very seriously. Okay, so again, another question I get a lot. Who has access to this information after they file this? And really, this is not a public registry. So I cannot go online and try to find this information. It is really restricted to federal law enforcement, the Treasury Department, local law enforcement, and any financial institutions if they're trying to do a know your customer diligence on you. It's not available through the Freedom of Information Act. So it's not public information. So please, and unless you live under a rock, I guarantee you your information is with somebody somewhere. I for sure know that Bezos is listening to us right now. There's no doubt about that. So really, if your concern is privacy, I think twice about that. And again, you're already disclosing a lot of this information through your tax return, so the government also already knows a lot of this information. So I understand the heartburn about this being one more step. However, it really is not that cumbersome or time consuming, again, if you're a simple entity. Really, the complexities arise when you have multiple entities, you have trusts that are holding multiple entities, you have multiple investors in multiple entities. If you are one of those, then please reach out to your corporate counsel or whoever your attorney is, because now is the perfect time to send out letters to your investors, to your shareholders, so that they can complete the steps they need to complete with getting the FinCEN ID or whatever it is they need to comply with, so that you can then stay compliant on your end. So what are your next steps? Hopefully, this has given you enough information to at least know where you need to get started. What is the information you need to collect? What do you need to start gathering? And then start to think about who would qualify as beneficial owners or company applicant. Timing is key, like I said, end of December. So December 31st of this year is your deadline if you're an entity that was formed before January 1, 2024. So please don't take this lightly. Go ahead and start thinking about completing this requirement now. And then keep in mind that if there are any changes to beneficial owners, your company applicant information, those need to be updated. So my recommendation to all my company corporate clients is take a look at all your governing documents, your bylaws, your operating agreements, your management contracts. Start incorporating these requirements within those documents so that you are already informing your management team, your owners, that this is something that they have to comply with. And if they choose not to comply with it, then I would say go a step further and include an indemnity provision in there, so that if you are on the hook for not complying with this with this law, because of your beneficial owner or a management team not providing you with this information, you have some sort of indemnity that you can fall back on, and get indemnified from these individuals. It's sadly, the government has not said what happens if a beneficial owner refuses to provide that information to a company. It is still the company's responsibility to comply with the law. So,
If that happened, would you go ahead and file with all the other beneficial owners and then just leave that one off, or how would you file?
yeah, so good question. So as of October 3rd, FinCEN released a clarification saying that they expect all reporting companies to at least report one beneficial owner. So if you do have these folks who are holding off, go ahead and file the report on time. And then you can always update when you get that information from that individual, or if you're not getting that information, please collect as much as possible evidence to show that, look, I tried my best to get this information, and so refused to provide it, so I don't know what you want me to do. Because at the end of the day, they're looking for, are you willfully violating the law? And if you can show that you weren't actively and willfully trying to say something wrong, then they should look into that as well. Because I will say the other thing that they say in the form when you fill out is, you are effectively confirming that all the information I provided is accurate to the best of my knowledge, and you're sort of providing that what's the word for it? Endorsement. And so as long as you can show that you did your best, but you have all of this other evidence to show that someone was a holdover, then it should be in your evidence.
Okay, yeah, and it doesn't look like on the form you can list that person's name and just say
No,
medicine not available, you just can't even list them.
correct.
Okay.
Good question. Very good question. Thank you, Michelle. Okay. So thank you so much. Was that 30 minutes or less?
Yes.
Yes. I was trying to get 30 minutes.
It looks like there was a couple of, maybe not a chat, but maybe some comments. Was there questions?
I just wanted to make sure that the questions were working, so that is my question, and I wanted to know, what happens if they miss the deadline?
Within the 90 days okay, so if they miss the deadline, if they willfully miss the deadline, so someone attended my workshop right now and they were like, I'm not doing this, whatever. That is a willful violation of this provision or this law, and I think that they can very much, FinCEN can come after you saying that you knew about it, you didn't comply, so all of these penalties apply. That's my interpretation of it. So far, we don't know if they have actively gone after entities, sending letters saying that, hey, you were formed 90 days before, what has happened? We've not seen anything come through, so it is very much they're hoping for the owners to comply with this requirement. Good question. Thanks. We have a hand up.
Thank you.
Edward, give me 1 minute. I am pulling it up. Okay.
So. Allow to talk, yeah.
All right, go ahead, Edward.
You're on mute though. Ask to unmute.
Oh, can you unmute, please?
There you go.
Hey there.
Don't hear anything.
Is our volume all the way up?
Can an individual use their office address, or do you have to use your home address?
So I'm assuming your question is that because I only heard half of it, Edward, it broke up your initial question or initial part of the question. I'm assuming your question is, when you file the report, can you use the office address or the home address of an individual? If that's the question, then for the company, you have to use the office address. For the individual, you have to use a residential address.
Okay.
Yeah. Okay, all right. Well, thank you all for spending some time on the very fascinating Corporate Transparency Act. If you have any questions, comments, again, feel free to reach out to me after. That's my email address. And now I have the very big honor of introducing Tiffany House, who is our amazing tax charitable giving and estate planning strategic expert, and she will be talking about some really cool succession planning stuff. So thank you.
Awesome, thank you very much. Well, it's great to be here with everyone. So I like to call myself a recovering financial advisor. I was in practice with my father for 17 years. And we focus on ultra high net worth individuals, and we helped them to save taxes, do estate planning, all in the context of asset protection and creating a master game plan. So we're just going to get into some succession planning today. And so how is it that we are actually able to have a successful succession plan for either our business interest, but also it's not just for all of our business owners, it's also about our wealth. How do we take our business assets, transfer them to the next generation, the next level of ownership, but also our wealth and our estate plan? How do we prepare the next generation to be able to successfully have that succession? Oh, sorry about that. Oh, oh, we're not sure. Oh, sorry. Okay, so one of my favorite questions to ask is how much is too much to leave to your kids? And it is a great question because the wealth transfer is actually something that needs to be done with well intent. Are we sharing now? Yes. Okay, perfect. And so the statistics behind this will show us, sorry, wrong way, that 70% of wealth doesn't even make it to the second generation, and 90% of wealth does not make it to the third generation. So actually thinking about passing on our values as well as our wealth to the next generation is part of what I call value-based estate planning. And there's estate planning attorneys out there who can draft your documents and all of that. That's great. But it's really important to look at how do we successfully enable the next generation to be able to not only take our wealth, but be responsible with that and potentially have it go on for generations, creating our legacy. So there's some great opportunities when we're talking about wealth transfer. If we do it right, whether it's a business sale or other types of wealth or at the end of our life, we have great tax savings opportunities. We're also able to teach morals and values, as well as nurture business acumen. So one thing that I love to do is when people put together, when there's some family wealth, I like it when they set aside an account that the kids or the grandkids can borrow from if they want to start a business. And it doesn't have to be a lot of money, but for those kids to actually start the business, they have to come up with the match. So if they want $25,000 to start a business, they have to save $25,000. How great is that to be able to teach morals and values and have them come to the family, this little small family bank potentially, of maybe just 50,000, maybe 100,000, that they actually have to write a report and act like they were going to the bank and asking for those funds. So there's some great ways that we can be creative with value-based estate planning. I also like creating family governance structure because there's really great resources inside of a family that are not only, they kind of exclude the financial capital, but is looking at the human capital and the intellectual capital. So when we have this problem of wealth not being able to transition to the third generation, if we're able to look at the people within the family and understand what their human capital and intellectual capital is and what roles that they might want to play in family governance, it can create a really successful opportunity for that family to create their legacy. Oh, and any questions along the way, feel free to interrupt and I am happy to answer them at any time. So one of my favorite ways to help a family transition is through philanthropy. Now that doesn't have to be money, that could be time or talent as well. But when we are able to teach the next generation what's important to us, I have some families that I work with where they will take kids at certain levels, maybe when they turn 16, take them on a trip and do a day together of volunteer work. That's passing on those morals and values as well. But there's some other tools that we can utilize. So there's something called a donor advised fund. And I love looking at business transition as well as wealth transition and utilizing tools. And I personally love charity. I have my own donor advised fund, and we have in our estate plan, 10% of our estate is going to charity. And when we sat our 3 girls down and said, you're gonna get 30% instead of 33 1/3, they got it. And part of that is we have a donor advised fund that our kids are going to be able to grant from when we're no longer here, creating that legacy. But a donor advised fund also is a fabulous tool for selling a business. If you're selling a business and you want to have some tax savings, there's some tools that we can use prior to the sale. But if the sale has already occurred and you're sitting in a big tax year, you can pre-fund your philanthropy. So I was working with a gentleman, he had an insurance company, he and his father owned a larger insurance company, came in and bought it. And he had kind of gone wayward younger in life, and he gave 10% each and every time he got a paycheck. And his accountant was going crazy because he was donating so much, little checks here and there. So what happened is at the time of the sale, it was an S corp. We did a goodwill sale, so it came out well tax advantaged already. But we were able to create a donor advised fund and pre-fund his philanthropy for at least the next 5 years. And what's cool about a donor advised fund is you utilize a sponsoring nonprofit organization. The donor then creates a fund that's inside that sponsoring nonprofit. They make the gift, but they get the deduction at the time of the gift. So now the accountant loves it because there's only one thing to report, right? There's only one gift that we have to disclose on the taxes. And what's really neat about it is you can give to charity whenever you want. I like to compare this to a private foundation. This is I call it sometimes the poor man's private foundation, but it's not for the poor man. It takes away a lot of the rules and it allows you to have anonymity. So it can be much more favorable than a private foundation. So it allows you to give to charity over time, and you can sell any asset inside the donor advised fund tax-free. Now that could be a business interest. There are donor advised funds that will take S corp stock, C corp stock, LLCs. You can put some of those interests into a donor advised fund, sell it tax-free inside of the donor advised fund. And now you not only get a deduction for the full fair market value of the gift, but any taxes that you owed on that asset now are sold in a tax-free environment. So you also get more tax-free compounding growth inside of a donor advised fund. And when I recommend for people to use a tool like this, very rarely am I going to say, oh yeah, put all your S corp stock inside of a donor advised fund, or all of your interest in something. We usually will take a portion of an asset and accomplish what we need for tax savings, unless it is that we're creating a legacy.
Is there minimum distribution requirement?
No. No minimum distributions.
Okay.
Yes. So you can gift over time. One other thing, I try to make my presentation a little shorter. I can go for a long time sometimes. It can also be, a donor advised fund can be a beneficiary of some of our charitable trusts and other charitable tools. So it can be the charitable intent, creating family philanthropy. So let's just take a look quick at the taxes on the transition of wealth. So for our estate taxes, they're at 40%. Now, currently the estate tax exemption is at $13.61 million for an individual, double that for a couple. But it is expected to sunset in December 31st of 2025. I believe that it's going to sunset because that would mean that we would have to have a good bipartisan effort come together to put in new rules and regulations on estate taxes and other taxes that were cut in the Tax Cuts and Jobs Act. I'm not seeing that really happen. But one thing to notice is that most assets get a step up in basis at death. What does that mean? So if you have real estate, if you have a stock portfolio and it's underneath that exemption, you're able to pass that to the next generation and it's going to be the what you paid for it will now go up to your date of death. So you won't have to pay taxes on that underneath the estate tax exemption, except we have to be careful of some income in respect to decedent of our qualified plans and investment entities. So will the estate tax sunset? We don't know, but I think it's good to do some planning for that as well too. So just a little bit of how the estate tax exemption works. So right now in 2024, we've got 13.61 million for one person. And let's say they go ahead and they want to make a $6 million gift to their children. So we go ahead and make that gift to the kids. And now if the sunset actually occurs, well, so then we have this 7.6 million left. If the exemption goes down to 7 million, they're only going to have $1 million left remaining for their exemption. So it's kind of use it or lose it. So if people are in the category above the 7 million, they might want to think about doing some planning for that. Gifts that don't qualify are medical, tuition, and annual gift exclusions. So what's an annual gift exclusion? Do you guys know that you can give money to people every year and have it be tax-free with the exemption? So each person is allowed to give $18,000 per person. So this looks like a complicated chart, but really all we're saying is that mom and dad can give each of their children and their spouse the $18,000. So 36, that's 72,000 per family. And then they can also gift that to the grandkids as well. So there are opportunities to gift in life. We talked a little bit about double taxation. Well, when we talk about income in respect to decedent, if you have IRAs that are high up there in value, there is the opportunity for them to be taxed both at the heirs rate. So whoever receives the IRA is going to have to pay ordinary income taxes on it. But if it's above the estate tax exemption, now there's going to be estate taxes on top of it as well too. So IRA assets can have a double taxation event.
Would you recommend getting them out of the retirement plans and paying tax on them now? Because then you save on the value of the estate, right?
Yeah, great question. So we're going to go into a tool that we can do to stretch our IRA payments out. There was a recent regulation that said that IRA payments have only 10 years to go to heirs. We're going to use a charitable remainder trust in this next example that's going to allow them to stretch out for their lifetime and even potentially for a term of 20 years for their kids. So that's something that I have done for that. Other people like to convert to a Roth IRA, and a Roth IRA, when you do that, you have to pay the taxes at that time. I have used a charitable trust with other assets to offset that taxation. So I would say I would not sell out of it now and pay the taxes, but I bet there's some tax planning that we could do around that.
So if you put it into a Roth, how long does the beneficiary have to liquidate that Roth?
I believe that the 10-year rule still applies for the Roth.
Okay.
And but
They
it's
would
all
get
after
these-
tax. So it's yeah, because they don't want the tax-free compound growth. So it would be 10 years.
Okay, but they still get the benefit of the tax-free earnings.
Yes, but they'd still get the benefit of the tax-free earnings, yes. And so would you, as you took out RMDs and that type of thing. So charitable remainder trusts, we're gonna go through two quick examples to stay on time. So I like to consider it as an apple tree. And the apple tree is the asset. This could be a stock portfolio, it could be real estate, it could be, in this circumstance, the IRA. And the donor gets to be the trustee, so they get to nurture the assets and say how they're invested. In this circumstance, we have the heirs receiving the apples or the income. And then at the end of the charitable trust term, the remainder is going to go to charity, but that could also be your own family donor advised fund. So you can do some nice legacy planning there. How it works is we take the IRA asset, and at the death of the owner, we're gonna go ahead and allocate that into, we're gonna make the charitable remainder trust the beneficiary of the IRA. And when we do that, we now get to have that asset's also outside of our estate for estate tax purposes. So we're avoiding that double taxation that could occur for people who have over 7 million of assets if the sunset occurs. We also get tax-free compounding growth and asset protection in there as well. And then if they sold outright, that just says that there would be a tax savings if they sold outright, but we don't want our heirs to do that. But sometimes we have bad heirs that might have addiction or money issues where they might try to sell their IRA all at 100% when they receive it. So here we're able to, at the end of the death of the heirs plus a term of years, the remainder is going to go to charity. And I mentioned it can be a family donor advised fund. We also get an estate tax deduction if we need it. But more importantly, we're going to get yearly income for the heirs. At the death of the heirs, if they're old enough, we can potentially do up to a term of 20 years for our kids and grandkids. And we get a lot of tax deferral, reduced taxes, and tax-free compound. So this can be a really powerful tool. And I'm going to flip through the next slide really fast because it's going to show doing this. I often set these up as two, and I'm not an attorney. I'm a flat fee advisor. I work with your great attorneys to help you come up with plans for the sale of businesses and for other assets that families might have. So here for Beth, we created her own $1 million trust. Her lifetime income is at $5 million because she was able to also stretch it out for 20 years for her kids. And her tax bracket was at 24%, so that's 3.7 million after tax. And then her brother, we did something similar. He is a little bit older and taxed a little higher, so his net was a little bit less. But when we combine the totals for both of these trusts, their total lifetime income is 9.5 million. And the after tax to heirs is 6.8. And this is on a $2 million IRA. So how I like to show things is in charts. If we take a look at this and if somebody took the money the first year and ran, so that's the full IRA payout, they would walk with, we're just looking at 1 million of it right now to compare apples to apples. They would walk with $630,000. If they did the 10-year stretch under the new guidelines, they would walk away with 1.4 million. If they had a charitable remainder trust that we just looked at, the family can have add the term of 20 years, and that gives them 3.8. So it can be a really empowering way to transition wealth to the next generation. Any questions? Sorry, I know I've got a lot of content, a little bit of time. I've been presenting a lot lately, and I think I added way too much into this presentation, so I apologize for that. So also there's the opportunity to have charity be your beneficial designation on your IRA if you didn't want to give it to your kids, because how much is too much to leave to your kids. So leaving it to charity is another great way to go about it. So we're in the perfect storm of business sales right now. 40% of baby boomers are business owners, and 10,000, I think it's more like 11,000 of them are retiring each and every day. So and there's been studies done that say that 79% of business owners have no written transition plan. So working with business owners is something that I love to do to be able to help them. And I work with charitable tools. Obviously, I've kind of been falling down that lane, but there's also non-charitable tools also that can be a real impact. And business owners are the most philanthropic class of people. So this is one of my cheat sheets. You'll see kind of in the top, kind of the yellowish, you have an S Corp, C Corp, LLC, or asset. On the left are all the tools and strategies that can be utilized to be able to do a tax advantage sale on those assets. So you can see here, if you have an S corporation, which most people have S corporations, your strategies are a little bit more limited than if you're a C corporation or an LLC. But there are a lot of great tax advantage solutions that can be utilized, and anyone's welcome to this cheat sheet as well. And I don't think enough people actually think about how businesses are sold and how they're taxed. So on $1 million business, most of the time too, people don't always think that when it's an S corporation, there's an asset sale or there's a stock sale. Most of the time, S corporations go as asset sales. The buyer wants to get a new step up in basis on the assets, and they don't want the lingering liability of the company. So let's do a best case scenario and do it as a stock sale. We are gonna have to pay 20% federal capital gains tax, the 3.8 net investment income tax, and then in Arizona, it's 2.5% state tax. If you do an asset sale, some of those assets are gonna come out as ordinary income, and then taxation can be even higher. So there's the charitable remainder trust that we talked about with having it be the beneficiary of the IRA. I like to tell people the guy who screams at you on TV about what stocks you should buy on CNBC, Jim Cramer of Mad Money. If you ever notice when he discloses what stocks he personally owns, he always discloses that they are in the Jim Cramer Family Charitable Remainder Trust. So it's been a tool that's been around for a long time. And I'm going to get to the nitty-gritty end of this, of how it works, which I have an example of it and then without it. And then looking at, let me see if I can adjust where this is. Yeah. So using and not using the charitable remainder trust on this left side, we have lifetime income at 1.5. If we use a charitable remainder trust, and here I even bought life insurance instead of the term of years that you could add to it, lifetime income went up to 2.2. The inheritance, the kids got a little 1.2 million without the trust. With the trust, we bought life insurance for $1 million. Charity ends up winning at nearly 2 million. But there was a big income tax deduction that we were able to get for our gift. And if we invest that over time, this family ends up 3.6 million ahead on $1 million asset using a charitable remainder trust. So it can be a really empowering tool, even if you're not charitable, because sure, we walked out with 3.6 ahead. Charity got 2 million of that. So the family came out 1.6 ahead, but on $1 million asset, that's pretty good. So any questions? I know I'm going really fast, so I apologize. And the last thing I wanted to just mention is if you have a C corporation, there's something called the 1202 that is out there that CPAs should be talking to you about. It's an exclusion that offers either 10 million or 10 times your basis. So if you have a C corporation, definitely talk to your advisory team to see if you qualify for the qualified small business stock. It can be very helpful. And with that, I'll just leave it open for questions.
Madam, is this chat enabled?
The Q&A section of it is, people can have to put their questions into that Q&A section instead of chat.
Okay.
There are no.
Question for you, I have a question for you too.
Yes.
So the qualified small business stock, is that something that can happen at any time of the lifetime of the stock ownership, or is that like it has to happen within, I don't know, 90 days of you starting the business or something like that?
You have to have the business for over 5 years.
Okay.
So you have to have held it for 5 years and it has to be acquired after 1993. So it needs to fall into that window to be able to qualify. There's a few other qualifications. There's outside providers that can let you know if you're qualified. There's also, your CPAs should know this information as well. They're just so busy with all the other tax stuff, sometimes this gets missed, and it can be super empowering. Now, if somebody has a business that, let's say they've only owned it for 3 years, you can 1042 exchange it into, I'm sorry, no, 1045 exchange it, 1042 would be an ESOP. 1045 exchange it into another qualified small business stock, and now you get more of that exemption as well. And the state of Arizona agrees with the exemption, so there's no Arizona state tax, there's no federal tax when you sell a C corporation that qualifies for the 1202 qualified small business stock. So it can be really empowering.
I think there was a question actually.
Oh. Great. And let's go back and share again. Or maybe I should just get to the. Yeah, I think those are the first ones, yeah. Those are Shruti questions. So, awesome.
All right, well, thank you, Tiffany. I will say to anyone who's a business owner or, works for large companies, the best time to talk to Tiffany is now, like before you are part of undergoing a sale or anything like that. Because once you are prepared for those next steps, then you can have better intelligent conversations with your acquirer. And understand, how you want to make the transaction work. So really, if you're looking for any creative ways for, again, legacy building, then Tiffany is really the person to reach out to. I literally just recommended her last week to somebody I was working with, and who wants to, have this creative way of doing things. So she's amazing. And then I stand corrected on the Corporate Transparency Act for inactive entities. So if it's an inactive entity, it's actually exempt, so you don't have to file anything. So that's why I go ahead and terminate it, so there's never any question about, did I have to file it? Did I have to do something, whatever. Just go ahead and just break it, like, demolish it.
Yeah.
Let's not even deal with that. But yeah, otherwise, if it was an entity that was created, this is where I got confused. If it's an entity that was created in this year, even if it existed for 1 day, you do have to file the report. But if it's an inactive entity and qualifies for those inactive steps, then you don't have to file anything. It's exempt.
Okay, perfect.
Yeah.
I did see the PO passport or driver's license.
If a beneficiary passport or expires in the future, do you need to update? Absolutely, yes, please update their information. If you get a FinCEN ID, Julie, for that person, then that FinCEN ID information has to be updated. That automatically updates if they've used a FinCEN ID for any entity. Hopefully that makes sense, but yeah, yes, the answer is yes. All right, well, thank you everybody for your time. Thank you, Tiffany, so much for that. I know that there was a lot and in 30 minutes, so I apologize for giving you a short period of time.
No, I was trying to chop it down yesterday and I didn't do as much as I should have.
And all of that stuff is super important, and very important to have discussed early on. So that's why I wanted you to be on here, because again, I do mergers, acquisitions all day long, and it's like, I cannot tell you the number of times people come up and say, why am I paying so much taxes? It's like, well, talk to Tiffany, like.
It's best to do the strategy ahead of time, and gifting to children can be a way to do it. So even if you have like a qualified small business stock, that C corporation that we talked about, you could gift shares to your kids, and now everyone's going to get the 10 million exclusion if you wanted to. So
Yeah. So, I mean, there's so many ways of doing it, and I think people just don't think about it.
Mhm.
So thank you again for sharing and for giving us your time.
Yeah, well, my nice thing is I get to create the strategy and then deal with the intellectual experts that help them actually come through and do the actual work, do the attorney work, do the financial advising, do the tax work. So I do strategy.
Well,
Thank you so much.
Of course, thank you. And again, if anyone has any questions, comments, concerns, anything, feel free to reach out to either Tiffany, myself, or the firm. And again, thank you so much for your time. Thank you guys.
Yeah.
And thank you everyone.
Thank you.